for tomorrow. It's an anticipatory bail application, Your Honor.
You have filed it in
I
registry.
will be filing today, Your Lordship.
It will come up.
For tomorrow, Your
Normal
Lordship.
course, it will come up tomorrow.
Yes, Your Lordship.
You just talk to the registry. Bail matters is usually taken on a priority basis.
Okay, Your Lordship.
There's no question of mentioning.
Highly obliged.
Daily list item number 1.
Yes. Who's respondent 3?
Your Lordship, on the last occasion, actually, we are not filing the written argument because I have mentioned the earlier occasion also, but due to by mistake, my colleagues, they have mentioned that we'll be filing the written argument. But I'm making a statement, Your Lordship, we are not filing because we are not necessary party also.
Okay.
So state is supposed to file the written argument.
All the parties have filed.
Yes, Your Lordship.
Lordship. Yes.
You also?
I'm appearing in item number 5, Your Lordship.
No, as far as this item number 1 is concerned.
Lordship, we have filed our submissions.
Yeah, yes. I'm for respondent 1 and 2. I have filed, Your Lordship.
This is only on the issue of maintainability.
Yes.
Prayers, parties have submitted that.
We have already filed.
Yes, Mr. Kumar.
We have filed the
Yes.
our return.
Your colleague have said so.
Yes.
Parties have mentioned, have submitted before this court that the written argument, as far as the relevant parties are concerned, have been filed. Mr. P.T. Sawan, learned counsel for the respondent number 3, has, however, submitted that no written argument would be filed, will be filed on behalf of the respondent 3. Accordingly, matter is now reserved for judgment.
Lordship.
This is for orders. Yes.
Item number 2.
Please, Your Lordship. Lordship, I humbly pray if this matter may be taken tomorrow, Your Lordship. As the learned DSGI is out of station, Your Lordship. He'll be coming back this evening.
The papers are required here.
Your Lordship was pleased to call for the records.
Oh, records?
Yes.
On pre-made by the learned, by the respondent, praying for accommodation on the ground that the learned DSGI is not present today. Matters adjourned. This is same tomorrow.
Highly obliged, Your Lordship.
Item number 4.
Please, Your Lordship, that Provident Fund, that case. Yeah.
Yes.
So, yeah, may submit Your Lordship. In fact, we are exempted from payment of Provident Fund from the 70s, Your Lordship. However, in 2014, the management, they thought that better we start paying something. So we want to surrender the exemption. And that didn't materialize. In spite of that also, the office keep on paying the Provident Fund. And that is so admitted by them in their paragraph also. And I also found out that though they have not admitted all, but some more are still there. Some of Provident Fund is still lying at the bank. Due to pendency of this case, they could not get it. And in the meantime, what happened? The penalty provision came. They issued notice for the penalty. So, due to that, the case is being filed. Both the 183 and 184, both the case were filed, both the penalty. If the penalty can be waived, all the money which are due to the employees, whatever we have paid and whatever are to be paid, some are lying with the bank, then we are ready to give to the Provident Fund. So, this is my plain and simple submission, Your Lordship. Now the problem, the penalty, of course, penalty to provision, there is a discretion of this Honorable Court to waive the penalty provision because we have been paying it.
The court of the or the authorities concerned? Is it discretion of the court or the authorities concerned?
No,
What is the
there's an
procedure?
appeal lies for the penalty. Suppose the commissioner then appeal lies. But the problem is here, that period when they issue the penalty, the notification which is under challenge, both the cases, we are under exemption. We are under exemption period.
You may be under exemption, but
Yes.
you have voluntarily, you see,
We paid.
paid. So that means that you have committed yourself to the process.
Yes, we have committed. That is one point, your lordship. But ultimately the exemption was done in 2019. The government has accepted the exemption in 2019. Your lordship. The exemption has been done in 2019. That the item number 6. There we have challenged that notification. In the item number 6.
Exemption was given, then revoked
Revoked. That exemption was revoked in 2019
by another.
by another notification. So during this period, it presumed that we are under exemption. So the penalty question doesn't come. But still, for the welfare of the employees, we are bound to pay their provident fund. So we have keep on paying it, Your Lordship. And now also, few are lying in the bank. I have got the instruction. So if the order falls from your lordship, if it comes from your lordship, that's fine. Whatever is there, we'll surrender to them. We'll give to them. All the employees, their dues, they deserve to get it. So only the penalty has to be waived.
Is it as simple as that?
Lordship, the penalty part is the tricky part is the penalty part. Lordship, under section, penalty is drawn under section 14B. 7, yes, Lordship. Under section 14B is the power to, for 14B, before coming to 14B, we have to go to 7Q because the proceeding is drawn under 7Q, under 7Q.
Interest payable.
Yes, Lordship. Now, as per the provision under 7Q, interest payable by the employer. The employer shall be liable to pay simple interest at the rate of 12% per annum or at such higher rate as may be specified in the scheme or any amount due from him under this act from the date on which the amount has become so due till the date of its actual payment, provided that the higher rate of interest specified in the scheme shall not exceed lending rate of interest charged by any scheduled bank. So, Lordship, here the interest is there. Thereafter, 7Q is drawn. So, 7Q is drawn, then 14B is drawn. So now, power to recover damages. So 14B, 7Q, then 14. I'll come to 7C.
14B.
14B, power to recover damages. When an employer makes default in the payment of any contribution to the fund, may it be pension fund or the insurance fund, or in the transfer of accumulation required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17, or in the payment of any charges payable under any other provision of this act or of any schemes or insurance scheme, or under any of the condition specified under section 17, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damage not exceeding the amount of area as may be specified in the scheme. Provided
The penalty would include the interest in 7Q or
yes, 7Q is there and also
just the principal?
14B. We have already given the table also in our summon notice also. Summon notice we have already given the table in the writ petition is also it's there. Even in the order also.
Page.
Page 48 and 49, Lordship.
Forty 49.
Either page 46, it's more clear, Lordship. Page 46.
This is notice of demand.
Yes, notice of demand, Lordship. Lordship, here we have given what is the damage, what is the interest, altogether total is 9,60,000.
Total is how much?
Total is in the repetition 184. If your Lordship is in repetition, either of the
In page 46, the here the amount is 12 lakhs 52.
might be in 183. It's 183 and 184 similar case.
This is 183.
183.
183.
So 183 it will come to 12 lakhs. It's total.
See, that is this 12 lakh. This is as on 9/6/2017.
Lordship.
To buy it now, it must have crossed.
Just for you.
It must have been 20 lakhs or more.
Yes.
Lordship.
So you have that much amount in your account.
Those are there. Whatever is there in the bank, it is there.
How much is there?
The exact amount I do not
You
know,
have to.
Your Lordship.
If whatever you say is correct, that whatever amount has been accumulated is now lying in the bank. If we take that amount plus interest, whatever, and it comes to
So
calculation has to be remade now.
May-
You have
may-
to make a fresh calculation.
No, may I just suggest Your
Calculation,
Lordship?
Because since this means this is the
So the proceeding ends there.
the proceeding no Lordship, here what happened, what happens actually, Lordship, why the suppose Lordship, I'll more specifically the chart is not here, Lordship. What happens, Lordship, suppose they are supposed for the month of January they are supposed to file deposit, they have paid in the later, like in the month of September or October, then that amount, the delay amount will come as the delay days will be counted under interest as well as damage.
Exactly.
So now here that chart is not there.
So,
Where it
see, let's put it in a simple
Yes.
simple ways that we can understand. If your demand as on 9/6/2017, according to your that page 46 in 183, is 12,52,145. So if the petitioner now is agreeable to satisfy this amount, would that end the matters there, or would you further make a calculation and say, no, as on 2024 this is the amount? Is that the process, or what is the process?
no,
what is the
no, the interest
act and the rule says?
It is the day on which means the amount is deposited. So we have to just check, just one day time may be given, we have to just see whether their pending is still there or not. If the pending is still the amount, if their amount is not due, or they have already deposited the amount, then it is the same amount. Or if the amount is like I am not sure whether any pending dues is there or not. If there is pending dues, then interest.
Mr. Mata,
Yes.
you are saying that after 2017 you have continued to pay. isn't
Yes,
it?
yes. till 28 last we have paid.
Okay.
20.
So you have,
Huh.
that is not,
Yes,
that
it
is not.
there. Your Lordship, all these documents are there that we have been paying. I think 44,000 from 2013. It is there with me. 44,200. Then last we paid, if your Lordship allow me. Last week paid 1,34,000 something we paid on January 2020. Then from March it was suspended license, so it is closed, defunct, non-functioning. Up to January 2020 we have been paying. Continuously we have been paying. So although the notification is under challenge in the next item, that withdrawal exemption, that notification has been withdrawn by the government. So during this period, means the penalties should not have come to us, because we are in the exempted period. Still, for the welfare of the employees, as an abundant precaution, we keep on depositing the company. Company thinks for the employees, therefore they keep on depositing. But some are lying with the bank, so if it can be disposed of, so whatever is there, we'll submit to the provident fund. Then thereafter they can walk out, because I don't want employee to suffer more. That's my submission.
You see, now the issue here is this.
The penalty,
Firstly,
only the penalty.
penalty is one part. The exemption issue is also there.
Yes.
The EPF organization has to be convinced
Yes.
that you have been exempted.
Yes. So,
So there, you see, then we have to rely on certain notification. or whatever.
otherwise, may I just suggest your Lordship, let our MD sit together with the officer concerned, commissioner, then walk out the modalities.
Lordship, I don't have any objection. If the MD sits, we are
MD
we
or
are happy
whoever
to
is
Whoever goes.
yes, we are happy. We are
all
ready to
the-
welcome.
I think that would be better, because why?
That will solve.
It has come to a pass that at this point of time, even if the the matter is disposed of, the issue of
Payment of
that
the-
unaccounted period is there, which is not reflected in the it's not on records. So like I said again, if you are insisting on penalty interest interest penalty till date, then that calculation has to be made. They have to justify that this is only there in the bank, or they are under that exemption. All those things have to be taken into account.
So they have to
you
sit
work it
together.
out.
Yes.
Lordship, in my affidavit, annexure C, Lordship, they have through their letter only, they have disclosed that their bank security is lying. Total face value of demat account they have given.
How much?
It is coming to around
1 crore 17 lakhs.
1 crore 17 lakhs.
So,
So then
therefore,
that-
let
so that
the
is-
office
that-
sit
that-
together.
Then that will cover,
Yes.
That will cover because they have already given the face
and
value.
that they are willing to disburse that amount.
And that is lying with the bank, whatever the case will be. So I feel that your Lordship, since to end them litigation, 3 cases can be disposed of, your Lordship, but only let the office
We'll do
staff
one thing then.
and the commissioner, they sit together and work out the modalities.
You walk out, and
Yes.
then you
Report
present
back
a, you
to
present a report.
Okay.
Present a report
Yes.
on your, if there's any arrangement made, which is agreeable by both parties. You file that. The matter can be disposed of
We can
without
dispose.
even going to all those calculations.
Yes,
and
yes.
whatever issues that are there.
Yes.
Lordship.
Because I am mainly concerned with the employees' welfare.
Lordship, the same with the provident fund also. We are thinking for the
Everyone's
beneficiary. only.
concerned about everyone, but
Yes. Yes.
how long will I? 1 week's time?
Because my office, so they will be there, but how long they will
My
take?
MD from Indo, can it be, I think, within 3 weeks' time or 2 weeks' time? So I'll inform them. They have to come and walk out.
Let it be 3 weeks, Lordship.
When the matter came up for hearing, it appears that the parties have submitted that this matter can be resolved amicably, and since it involves calculation of the amount due and payable to those who are entitled to the same, it is the submission of the learned counsel for the petitioner as well as the respondent. Your respondent?
State is there.
State is there.
State, I think, has nothing to do with this.
No, only state they had exempted.
Only that exemption part is there.
Exemption.
It was
So
granted by the
if that is solved, then I don't think if they, I mean, if they agreed upon, because exemption would also, entails a certain amount, and a certain dues. So if that is sorted out, then it becomes, it becomes infructuous.
ultimately it's between the provision fund and the
Your respondent,
234.
for the respondent 2, 3 and 4 respectively, have sought for some time to allow the concerned officials from both sides to work out the most viable solution to this matter. On prayer made, the same is allowed. The media of prayer made, on consideration of the submission made, the same is allowed. As prayed for, it is expected that the parties meet. It is expected that the parties sit together at the earliest possible time and to file a report of their decision before this court within
4 weeks' time, I think, Lord.
within the next date fix.
4 weeks' time.
As prayed for, this is matter up to 4 weeks.
And even the penalty can be discussed if the order falls from your
No,
lordship.
that will.
The penalty is only provision is there.
No,
Lordship.
the penalty can also be looked into
If
by the
there's
parties.
yes, you see, if what we do is when you sit together,
Yes.
you will discuss all these issues.
All the issues.
It has to be a compromise.
All the issues, including the penalty, also, if lordship can put that word.
All issues.
Lordship penalty, because penalty part, Lordship, here I am submitting, I am differing with my senior that penalty part is it's once the penalty is imposed only by the act, it is through the appellate authority can be. We cannot. We don't have that
Then
power.
we have submitted
And who is the-
226 for that.
Has the appellate authority has not been moved in this?
Lordship, no. Appellate authority, because
We
under
have come
7I,
straight to the High Court, Your Lordship.
7I appellate authority is there who has the power. So Lordship, in other cases also I have mentioned that appellate authority has the power.
Anyway, you first work out. If you have enough money with you, then you give it.
Then it will
And then
suffice.
even as far as the penalty is concerned, then we can work it out. No?
That
Can be in a phased manner.
no,
or
therefore,
can
if
be-
that falls from your lordship here in the order
but
set,
if you see, if that is contrary to the provision of the act, then the court cannot pass an order which is contrary to the act. If the
no, but
issue
your
of
lordship
penalty
exercises
is to
some
be
discretionary
decided-
power.
See, if the discretionary power falls only on the appellate authority under the act, then only on a decision by the appellate court, or by the appellate tribunal, whatever, or the appellate authority, it comes before the High Court then. But that stage has not reached. So if at all a decision is, if this matter is disposed and you are aggrieved by certain, certain
Settlement,
decision,
etc.
you go before the appellate authority.
All right.
And the appellate authority, if it passes any order, it waives the penalty or otherwise, or does not do it, then you
Then
can,
I can come back.
can come back.
That's obvious.
So 4 weeks,
4 weeks time. Deeply obliged. Then item 4 and 6 say.
4 and 6.
6, the notification of government we have challenged because without giving notice that they have
Same order.
Same order, 4 and 6. Deeply obliged.
But my request is, see, 4 months, 4 weeks time has been given to you. Please do it.
Yes, yes.
Otherwise, don't come back on the after the matter is listed and say that we have not been able to set. We are not. You disagree or you agree? It's up to you. But you come with.
Lordship.
Yes. In fact, all statements we have given there, only it's up to them. We'll just, because this has been defunct a company, therefore I have to request
And
them.
take into account the latest status.
Yes.
See, that has to be taken into account.
Lordship.
I'll work on that.
Thank you.
Deeply obliged.
Item number 5.
His Lordship. Item number 5 is connected with the item number 1, Lordship. It's the same issue with regards to the, whether the locator can be made a party. Same.
Okay. And this matter has been heard. So
This is also matter has been heard.
So
Here also we are not filing the written.
you are for
for the private respondent.
respondent.
Respondent number 5,
Respondent 5.
Lordship.
What about respondent 2 and 3?
4. Respondent number 4.
Who is 2 and 3?
I'm for 2 and 3, Your Lordship.
Have you
I'm for the
filed?
Lokayukta.
Have you filed your written
Yes,
argument?
we already filed, Your Lordship.
We have one madam. State is respondent number 1. And madam, it is, we are relying on item number 1, madam, which states appeal, madam. So we don't have to fight.
And Your Lordship,
But you see, that would be confusing.
Here we are formal party, madam, apparently. We don't have any role.
Okay, so you take it that you are not filing any argument. What would you have you filed?
We are relying on the and the argument filed by the state under item number 1.
You see, even if that is so, you file a formal written argument. File a formal written argument so that it will be, see, when the matter is disposed of, it may be disposed of with by a common judgment, or it may not. It depends on the facts or how the law is discussed. So it's better so that it will not be confusing. Otherwise, this court will have to look at the other petition, then look at this petition, and then there may be some confusion there. So you file. You may just repeat, you may just copy paste their argument, whatever. That's up to you. But at least let it be on record.
Your Lordship, we are filing a comment written synopsis in item number 5 also, Your Lordship. We filed in item number 1, so we're relying on that, Your Lordship.
But have you filed a separate?
No, Your Lordship. We're filing a comment.
Common, no doubt. You see.
Your Lordship.
Okay, common, but copies.
Okay, copies. We'll do
Separate
that.
copies.
We'll do that.
Do that in the course of the day. You can do
Yes,
that.
Yes, Lord. If not today, tomorrow, Your Lordship.
Yes. Your
So
Lordship.
at least this matter tomorrow.
Yes. Okay, Your Lordship.
Learned counsel to the petitioner as well as the learned counsel to respond 2 and 3 are submitted that they may be allowed to file the written argument in course of the day. As prayed for, this is matter tomorrow. And then,
Udah naman item 1. Item 1 udah naman it's connected.
I don't know what is happening.